10:30. So let's go ahead and get started. Hello, everyone. I first would like to welcome you all and thank you for spending the next hour or so with me. Today's webinar is on the impact of the coronavirus on Michigan workers' compensation. I'm Alicia Birach, a partner in the Employer Services Group at Foster Swift. Over the last decade, my practice has primarily focused on workers' compensation defense. First, a few housekeeping details. We are recording this session and we'll email you a link to the webinar to the address you used to register later on today. It will also be available on Foster Swift's website on the coronavirus resource page. To minimize background noise, we have muted incoming audio. I welcome your questions, and we have the question feature enabled. Please go ahead and type your questions, and I will do my best to answer them as they come in. In addition, I reserved some time at the end of the webinar for additional questions. And you can always email or call if after the fact something comes up and you have a question that you'd like us to address. All right, well, let's get started. I'm sure you are all experiencing the coronavirus and COVID-19 and how it's rapidly changed our day-to-day lives. It's also rapidly changed the practice of law. And so there have been a number of changes to the structure and laws related to workers' compensation defense here in Michigan and the ways we operate in this practice area. Today, I'm going to share with you an overview of those changes, and we'll give you information on issues that we anticipate you and other employers are either currently facing or we expect you probably will face over the next several months. I'll try to provide you with some guidance on how to approach those issues. All right. So the first thing really to talk about is how it's affected the hearings, because I think that was the first change that came about as the coronavirus took hold here in Michigan. Effective March 16th, 2020 at 5 p.m., the agency canceled all in-person hearings. This means that control date hearings are currently being held telephonically with the agency and with plaintiffs' counsels. In addition, facilitations at the option of the attorneys can be conducted telephonically. That is something that needs to be prearranged in advance with the magistrates. On some cases, that's something that's very doable. On other cases where there's multiple co-defendants or there's some excellent surveillance that you really want to get in front of the magistrate to have the biggest impact, it's not as doable. Fortunately, the magistrates are understanding of this, and at this juncture, they're not forcing any of these cases to facilitate. It is at the choice of the attorneys and the magistrate, but it is an option and it can be done telephonically. So if there is a case we are looking to get moved along and we think, hey, this is one that easily can be handled over the phone, we have the option to do that. The magistrates are also handling redemptions telephonically. This is a little more tricky. Obviously, the defense end will prepare the initial paperwork. It has to be sent over to the plaintiff's attorney, who then has to get it to their client, who has to get it signed and notarized back to their attorney, who signs the documents, gets it back to defense counsel, who signs the documents, and ultimately sends it to the magistrate. It needs to be to the magistrate within 3 business days before the date of the planned redemption. And then all the parties need to be available as well by phone. So that's something that we are doing and is something that has allowed us to continue settling these cases at this point and getting things resolved and off the dockets. I think most cases, this is something that can be done. It takes a few extra steps, but with the rare exception of a case where you have maybe a plaintiff who's understanding you want to make sure you get on the record and you really need to be there in person to ask them those questions. This is something that really, I think a lot of attorneys are going ahead and doing telephonically at this point. In addition, and this is at the sole discretion of a magistrate, necessary trials and some in-person redemptions will be allowed. A necessary trial is a very high bar. It's been made pretty clear that approval for a in-person trial or redemption will be few and far between. And again, that's at the sole discretion of the magistrate. Currently, the closing of the actual in-person hearings is to last through April 20th, which is this upcoming week. However, we anticipate that the closure of the bureaus and the in-person hearings will be extended throughout the duration of the governor's stay home, stay safe orders, which currently run through the 1st of May. So although it is scheduled to end on April 20th, we don't anticipate that actually being the case. And we think this is something that might, go on as long as these stay home, stay safe orders are in place. So it has really changed the way we are conducting this practice at this point, and it's requiring a lot more communication back and forth between the attorneys on a much more frequent basis, because we don't have the opportunity to sit down for an hour and a half with these attorneys and talk to them in person at these hearings. In addition to having an impact on in-person hearings at the Bureau, there's been some questions raised about, well, how does it affect our ability to bring an appeal, or if we have an appeal pending, how does it affect the dates and deadlines? And the Workers' Disability Compensation Appeals Commission is still operating. The commissioners, there are 3 of them, and they are working remotely. They have put out guidance that all filing deadlines should still be followed. They do recognize that a lot of these tasks that would take, a much shorter duration of time to complete if we were all in our offices and everything was open and we were operating business as usual, those are taking a lot longer. So what they pointed out is, though all of the filing deadlines should be followed and still stand, the Act does allow for further time for filings for sufficient cause. This is something they'll evaluate on an individual basis, and it will be based on the facts in that specific case. A recent opinion was issued by the Workers' Disability Compensation Appeals Commission, Bryant versus On-Time Medical Transportation, which granted further time to file a brief upon showing of sufficient cause. There was a challenge to whether they had the authority to allow sufficient time to file a brief. In their opinion, they do. So that is the opinion that's out there on that issue right now. Obviously, it could be subject to additional appeals. They have also stated that additional time to file a cross appeal or a brief in support of a cross appeal cannot be granted. That's not within their realm of capabilities to go ahead and do. Any filings to the Disability Compensation Appeals Commission should be made ideally by mail or fax. So be cognizant of this when you're looking at your deadlines. Overnight deliveries are still being accepted, but they've cautioned you should speak with the carrier who's making the delivery to make sure this can be arranged. There isn't really reliable access to the buildings at this point because access is limited. So that's something to keep in mind if you do have an appeal pending and you're working against filing deadlines, making sure you allow enough time to get the documents where they need to be, given that, in-person hearings, in-person deliveries, hand deliveries, and overnight mail may be more difficult to do in the current climate we're all operating in. So since the coronavirus took hold here in Michigan and the governor issued the emergency, state of emergency, there have been several emergency rules and directives that have been put into effect which directly affect Michigan workers' compensation. The first were the emergency rules promulgated by the governor on March 18th, 2020. The second were the emergency rules which were filed on March 30th. And lastly, the newly appointed director, Jack Nolish, who is now the director of the Michigan Workers' Disability Compensation Agency, he put out a directive on employers, insurance companies' ability to reduce and terminate benefits during the duration of the stay home, stay safe order. So those are the three things we've, kind of been dealing with in terms of changes to the law at the moment, law and rules. So the first is the emergency rules filed on March 18th. On March 18th, Governor Whitmer, in conjunction with Jeff DeFerino, the director of the Department of Labor and Economic Opportunity, promulgated some emergency rules related to first response employees. The emergency rules that came out on March 18th, these were very, very relevant because they created an irrebuttable presumption that if a first response employee sustained a personal injury, it created a irrebuttable presumption that if a first response employee was quarantined at the direction of the employer, received a COVID-19 diagnosis from a physician, or received a presumptive positive or laboratory confirmed diagnosis, there was an irrebuttable presumption that that diagnosis or that quarantine was a personal injury that arose out of and in the course of their employment. So basically, if you were an employer of one of these individuals classified under the emergency order as a first response employee, and that person was diagnosed with COVID-19 or was ordered by you to stay at home in quarantine, that was 100% a compensable workers' compensation claim, and you were not in a position to rebut that. So there was no onus on the employee to show that the COVID-19 occurred in the course of or arose out of their employment. It was something that just needed to be paid as law. And that, again, only pertained to first response employees, which were defined, albeit very broadly and somewhat confusingly, by the order. So the question would be, who falls into this category of a first response employee? And as I said before, the definition under the first set of rules was very broadly defined. Basically, it included a number of people in different capacities who were working for ambulance services, EMTs, any doctor, literally it says any physician in a healthcare capacity, nurses, and police. The way it was worded was slightly confusing, and it called into question, well, is it all police officers? What about county employees? So what if you work for the county, but you're working in the capacity as what most would consider a police officer? How does that work? And so there was some confusion there, but after review of the order and the various provisions it referenced in other areas of Michigan law, it was pretty broad reaching in its scope. And basically, if you were any sort of first response professional, from an ambulance driver to someone working at the ambulance facility itself, to a healthcare worker, someone working at these in these healthcare settings, including in industrial clinics, you were presumed covered under this irrebuttable presumption. There was a lot of question as to whether or not it was constitutional, given, it was a change to the rules, but really it was a change to the law and significantly impacted the scope of who was covered by the Workers' Disability Compensation Act, and in what capacity, since it was an irrebuttable presumption. Those rules were revised, well, not really revised, they were superseded by a new emergency rule, which went into effect March 30th, 2020. And so the new emergency rules completely supersede the first set, and there are some significant changes between the first and second set, although both do pertain to these first response employees. So the second set of emergency rules promulgated on March 30th, 2020, fortunately removed the irrebuttable presumption. Under the new emergency rules, first response employees who are actually diagnosed with COVID-19 are presumed to have sustained a personal injury that arises out of and in the course of employment. This diagnosis can be made by a physician or a test result. So they don't necessarily need to have a positive test if they are diagnosed by a doctor who has not performed a test, but they have all the classic symptoms and the doctor is saying, hey, I'm diagnosing COVID-19, that also counts. The new rule does not include quarantined first response employees. So if you tell an employee you have to go home, that's no longer covered necessarily as a compensable injury under this presumption. Obviously, the most significant change is that it is now a rebuttable presumption, which it was not before. Under the new rules, a claim may be denied only if there are specific facts demonstrating the first response employee was not exposed to COVID-19 in the work setting. This requires the employer to disprove that the first response employee's COVID-19 exposure arose out of and in the course of employment. The employer's denial must be based on specific facts demonstrating the first response employee was not exposed to COVID-19 at work. This is obviously a very, very high bar if you're working in a first response capacity. So if you're, an EMT or an ambulance driver and, you're transporting patients who have or suspect to have COVID-19 frequently to and from their homes to the hospital, and you contract COVID-19, showing specific facts that they weren't exposed in the course of their employment will be near impossible. On the flip side of that, where this benefits employers and carriers is that just general physicians who were covered under the wording of both the first and the second set of emergency rules, who, let's say your orthopedic that you treat with for your bad knee in his office, not at the hospital, who is not treating COVID-19 patients necessarily, he's seeing patients with, knee problems, whereas they would be covered by the irrebuttable presumption. And now this rebuttable presumption under the former set of rules, that was it. If that physician who was in orthopedics in a private practice in his own building offsite from any hospital contracted COVID-19, but he was seeing patients, he was covered, and it was an irrebuttable presumption. Now we have this rebuttable presumption, so you could point and say, well, hey, this person, this orthopedic, isn't working in a hospital setting. There aren't patients with known diagnosis of COVID-19 coming in and out. None of the people he has seen have been diagnosed or tested positive for COVID-19. Now you're in a position where you could make an argument that such physicians shouldn't be covered and aren't entitled to benefits in those types of situations. But as I said, it's an exceptionally high bar. Most first response employees will likely have been exposed in hospital settings or emergency settings. And so you'll really need a lot of specific facts at hand to rebut this presumption. And the penalties are quite steep. Under both the original set of rules from March 18th and these current set of rules from March 30th, you're subject to penalties under MCL 418-631. So section 631 of the Workers' Disability Compensation Act. And those penalties are very, very steep and include revocation of licensure of an insurer or an employer's status as a self-insured. Specifically with regards to The new set of rules, they are also subject to the same penalties under Section 631 of the Act. So it's something that we want to make sure we're really doing our best to, follow and are cognizant when an adjuster or carrier or an employer gets a claim and that person could potentially be classified as a first response employee. It's something you really want to look at and make sure you understand, one, do they fit the classification? And two, if they do, are there strong specific facts supporting our position before you dispute? So the good thing about the new set of emergency rules from March 30th, 2020 is they hone in a little better on exactly who is classified as a first response employee. Excuse me. So under the emergency rules promulgated on March 30th, a person working in ambulance operations and advanced emergency services, county medical care facilities, emergency services, hospices, hospitals, nursing homes, those people are all covered. And keep in mind when you're looking at this, that a person working in an ambulance operation, we're not just talking about the drivers here. We're talking about the person, answering the phones, dispatching the calls. Those are all people working in an ambulance operation. It is not limited to the drivers and to the EMTs who are actually working on the patients in those settings. A person working in a home health care agency or a visiting nurse association, any person working as a physician, physician assistant, nurse, emergency medical technician, paramedic, or respiratory therapist. Again, here's where we see some of the benefit of the rebuttable presumption coming in, because some of those people, albeit they're a physician or physician's assistant or nurse, there's, people working in those capacities every day who aren't necessarily treating COVID-19 patients and who we may have an argument that we could make that they weren't exposed at work. But again, a high bar, and it will be based on specific facts. Police officers, firefighters, emergency medical technicians, on-call members of fire departments, volunteer civil defense workers, on-call members of life support agencies, or members of an emergency rescue team. There's also the members of the state police or an officer of the motor carrier enforcement division, and then state corrections officers or local correction officers. So it covers a broad spectrum of people working in both the medical field and in our police and fire departments and prisons. So the scope is quite broad, but the new emergency rules definitely do a better job of defining who those people are. Now, as I touched on earlier, Director Nolish, he put into play a directive. He put out a directive discussing carriers and employers' abilities to reduce and terminate benefits during the stay home, stay safe order. So basically, this was mostly in regards to terminating benefits based upon a missed independent medical exam, or reducing or terminating benefits based on a vocational evaluation, a Stokes. And essentially what he said is, under the Stay Home, Stay Safe order and Executive Order 2020-20, people are not supposed to be going out for, non-essential medical services or non-essential anything really at this point, right? I mean, we're only supposed to be leaving our homes for an essential purpose, which includes, going to the grocery store or needed medical treatment. So that being said, an independent medical examination doesn't necessarily fall under that scope. I'm going to pause here because I see we have gotten some questions in, and so I want to take a look at those before we move on. So the first one was about a Detroit bus driver. It says, was the Detroit bus driver that posted the video of the passenger that was coughing on the bus who later died of COVID-19 diagnosis covered under workers' compensation? Just curious if you have any awareness on how that case is being handled. Essential employees are much an issue as first response employees. And whereas I would agree that essential employees are as much an issue as first response employees. At this point, the director and the governor haven't put out any emergency rules related to essential employees. The only emergency rules we are seeing are related to the first response employees. That being said, I strongly suspect we are going to see a surge in cases from essential employees, which is something I'm going to cover in a bit later on. I wouldn't be entirely surprised if there was some guidance given related to how these claims should be handled at some point from either, Jack Nolish in terms of a directive, or from the governor herself with another emergency type order. But again, at this point, there is not, and the Detroit bus driver would not fall under the classification of a first response employee, so he would not have been covered by those. Now, whether or not it's covered under workers' comp is still a question. And again, we'll cover this more later, but a person like that bus driver, if his, the representative of his estate could show that he contracted the coronavirus in the course of his employment and it arose out of his employment, then yes, it would be a covered injury. And in that case, I know there was a question about whether he contracted it because there was a woman with symptoms coughing on the bus he was driving, and he came down with it, within a few days, within the incubation period of his exposure to her. And so did she have it? Is that how he got it? It's a factual determination, and someone, a representative of his state, I'm sure could make a claim for workers' compensation benefits, and then there'd have to be a factual analysis where they'd have to show that it did arise out of and in the course of his employment to get those benefits. But again, there is no presumption, rebuttable or irrebuttable, with first response employees, right? Or sorry, with non-first response employees right now, like the bus driver. So they would just be subject to your typical workers' compensation analysis where you look at the case and decide, did this injury arise out of and in the course of? But again, I wouldn't be entirely surprised if the governor or the director at some point issue some additional orders or guidance related to essential employees. And again, we'll talk about this later, but Michigan uses the increased risk test to make a lot of these determinations. And I think a lot of those essential employees are arguably at increased risk. So some of those claims will be compensable. The next question is, do you feel those employees working in a juvenile detention facility would be considered first responders? They're not police officers. Suppose someone could make the argument they are a correctional officer. However, their title is juvenile detention specialist. So that's actually a very good question. And the line of thinking used in the question is where my mind goes. It's going to hinge on whether people working in these juvenile detention centers are classified as correctional officers. It's not clearly defined in the order itself, but it's something that you would have to look to other areas of the Michigan law to see how the legislator in other areas has defined correctional officer. It's something I can definitely look into further and get back to you on. I know that when we're looking at the intent of what the governor was trying to do, it's pretty broad in scope. And so if it's a juvenile detention specialist working in one of these juvenile detention centers, it seems to fit within the intent of the emergency order that they would be covered. But again, it's something that we would look to other areas of Michigan legislation to see how correction officers are defined before giving any final guidance on it. But as we've said before, there are steep penalties associated with this. And so something you would definitely want to also consider is, did this juvenile detention specialist, were they exposed in the workplace? Would it otherwise be compensable even if it wasn't covered on this order before you started making disputes with that respect? But that's something I can definitely get back to you on. And as I have these questions and I can see your questions, I can see who's asking them. So it's something I'll be able to email you back on directly. So But that's a very good question. But yes, at first blush, I would say a juvenile detention specialist probably does fall under that umbrella of a correctional officer, but it's something definitely worth looking into further. How will the new emergency order apply should a first responder die from COVID-19? So again, a death resulting from COVID-19, so they have this personal injury, right? Because we've established that a first response employee, there is now a rebuttable presumption that the COVID-19 arose out, it was a personal injury that arose out of and in the course of their employment. And so if they pass away from the results of that personal injury, then it would be compensable. And so unfortunately, that's, you know, something that I think we are going to see a lot of, and I know is on a lot of carriers' minds. But the way the emergency orders are written is that if you qualify as one of these first response employees, there is this rebuttable presumption that your personal injury arose out of and in the scope of your employment, and then, you know, it would follow if you pass away from that personal injury that is also covered, just as in the case of if, you know, you have a contractor who falls off the roof of a house and sustains, you know, massive internal injuries. It's a personal injury, and then they subsequently die from those injuries. It is compensable under the Act. The next one is, at what point does an employee file a comp claim? For example, if a deputy tests positive for COVID-19, but the municipality has elected to include those employees in the FFCRA benefits and the employee is utilizing those 80 hours, when is the claim filed? After the 80 hours has been utilized, if the deputy is still off? So basically you're asking at what point you should start paying the workers' compensation benefits. So technically the claim would start on the day of the injury, especially because, you know, even though they're receiving benefits through the CARES Act, excuse me, in terms of wage loss, there's also the issue of medical and medical treatment, which would be covered under the Workers' Disability Compensation Act. So that claim would start, you know, at the time of injury and at the time you become aware of the injury or the COVID-19 diagnosis with these first response employees. That being said, the Workers' Compensation Act does allow for offsets to wage loss benefits for like benefits, and arguably the ongoing payment of wages for those 80 hours would constitute like benefits and could be used to offset the wage loss they would otherwise be entitled to under workers' compensation. So I would offset the amount received in other sources of income, be it sick leave that the employer is choosing to pay, or, you know, leave under the CARES Act, against the workers' compensation wage loss benefits that they would receive. And then after the 80 hours, you know, when they're no longer receiving sick leave, you know, sick time, or, you know, the money under the CARES Act, at that point, that's when the wage loss benefits would kick in terms of making the payments, because you don't have anything to offset the wage loss benefits with at that point. We have an animal control officer who contracted COVID-19. He works out of the police department and receives his salary from the police department budget. We do not consider him to be a first responder per the 3/30/20 emergency order. Do you agree? So that is one that I think we would need more information to give you further guidance on, because they are being paid out of the police department. And so it's something I'd want to, again, since it is such a high bar in terms of who the intent was to cover, and the penalties are so steep, we'd want to make we'd want to make real sure before we didn't classify them. So we'd want to look and see how under the emergency rules and some of sort of the other Michigan legislative guidance that's out there and definitions of police department employees, how those people are classified, because they are being paid by the police department and they work out of the police department. So arguably they're being exposed to those police officers. So that is something that I will look into, and we'll get back to you further on, because there's some ancillary issues there that we'd want to explore before giving you an answer. Obviously, an animal control officer typically wouldn't be considered a first response employee, but because they are working out of a police department and being paid by a police department, there's some concern that they possibly could be covered. All right, so we'll get back to you further on that one. And then, do you see underlying comorbidities as an opportunity to potentially rebut the presumption in the event of a COVID-19 death? No, not with these first response employees, at least. You take your plaintiff as you find them. So just like in a regular workers' compensation case where you have an employee with some pre-existing condition that makes them more susceptible to injury. If they're injured, you still own that injury. So, I think we see it a lot in terms of, you've got somebody who, excuse me, sorry, I have this cough, but no, don't worry, it's not COVID-19. It's just the typical seasonal allergies and changing of the weather and being cooped up in a house with recirculated air all day. So in terms of the underlying comorbidities, the injury itself is the diagnosis of the COVID-19. The fact that they were more susceptible to a poor outcome because they had hypertension or diabetes or any one of a number of these underlying conditions that they're saying are leading to more adverse results. Unfortunately, that won't be a defense because you take your plaintiff as you find them, and the injury itself was the contraction of the COVID-19, and the impact of that injury will vary person by person. But unfortunately, it won't be a defense to rebut the presumption. Having hypertension, having diabetes, it doesn't make you more likely to contract COVID-19. It makes you more likely to have a negative result from COVID-19. And those are, the two separate issues you really need to look at, because when an injury is considered compensable, it's on the basis that it arose out of and in the course of his employment. And those comorbidities don't have any impact on whether the COVID-19 how it's contracted. And so, whether it arose out of the course and scope of the employment. If any employee files for workers' compensation for COVID-19, how does it offset with the 80 hours paid sick time? Does the city pay the employee for the paid sick time, then workers' comp kicks in? We touched on this. Someone else had also asked a similar question. And under the Workers' Compensation Act, you can offset wage loss benefits by like benefits received. So you could use the sick time to reduce the wage loss. So, most of the time, someone is paid more in sick leave benefits than they are entitled to receive under the Workers' Compensation Act, since it's 80% of the after-tax average weekly wage. And so likely those benefits would extinguish any obligation to pay wage loss benefits while those other benefits are being, paid to the employee. And then at that point, when those benefits expire, that's when the offset, you no longer have an offset, and you'd have to pay the full workers' compensation rate going forward. But in terms of when the claim starts, it's when the person contracts the COVID-19 and lets you know, because as you know, with workers' compensation, in addition to just the wage loss, we are on the risk for the medical expenses related to the injury. Okay, so those are the only questions we've had come in so far. So I'll get back to talking about the directive out of Jack Nolish in terms of reducing and terminating benefits. So basically what Director Nolish is recommending is that any independent medical evaluation scheduled throughout the duration of the Stay Home, Stay Safe order and Executive Order 2020 be canceled. And so basically any IMEs which are scheduled before May 1st, they're saying cancel them. There's no obligation for the plaintiff to attend. And if a carrier or an employer threatens an employee relating to attending the exam, there are steep penalties. And then the real question will be what happens after May 1st, because after May 1st, do some of these social distancing guidelines stay in place? Do some of the directives that non-essential medical shouldn't be carried out stay in place? If that's so, then are we precluded from getting independent medical examinations for a longer duration until non-essential medical is allowed again? So those questions obviously will come into play, and we won't know the answers to those until we get more information from Governor Whitmer or the executive orders actually do expire, in which case we know this guidance is no longer on the table. The failure to attend an independent medical evaluation or conduct a job search should not adversely impact on the entitlement to benefits. Basically what Director Nolish said was, there's really, no basis to argue someone's wage loss benefits should be reduced based on the failure to conduct a job search right now, because what he said is any jobs that are identified are likely not available right now. Either the employers aren't hiring or they're not even open because they're subject to these orders. So they said that benefits should not be terminated on the failure to attend an IME, and they should not be reduced or terminated based on a vocational evaluation and arguable residual wage earning capacity throughout the duration of these orders. And any demands or threats to an employee related to attending these IMEs or conducting a job search while the order remains in effect would be considered a violation and result in penalties and fines. He specifically indicated that a willful violation could be considered a misdemeanor. So again, these are high bars, so we're advising all of our clients at this point that any IMEs through at least May 1st need to be canceled, and that we're not in a position to use residual wage earning capacity to reduce or extinguish wage loss benefits on cases where we haven't already done that at this point. Okay, it looks like we've gotten some additional questions related to this, so let me move over to those. How would exposure prior to 330 be handled under this new ruling, 330 ruling, the 318 ruling, or pre-COVID workers' compensation treatment? We have several exposures in early to mid-March. So the March 18th and March 30th rulings, executive orders, only apply to first response employees. So if you are dealing with a first response employee between March 18th and March 29th, you will need to follow the executive order issued on March 18th with the irrebuttable presumption. You are looking at any injuries after March 30th, then you're looking at the March 30th rules. Now, the March 30th rules do supersede the March 18th rules. So now you have an irrebuttable presumption, or sorry, you have a rebuttable presumption now. So if you were paying anyone from 318 to 330 who you think you can show specific facts, again, a very, very, very high bar that they were not exposed in the course of their employment, you could try and make that argument at this point for those injuries. In terms of people exposed before 318, the executive orders weren't in place, obviously, before 318. So those initially would have been treated as as just a regular workers' compensation claim, and that's the way you would have done the analysis in terms of 318. Now, if they are first response employees and they did have a COVID-19 diagnosis prior to the 318 ruling, there's some room for argument there, but I would still treat it as compensable if they were a first response employee. I would follow the irrebuttable presumption that's currently, or sorry, the rebuttable presumption under the March 30th guidelines, because that's currently what's in play right now and supersedes anything prior to that. If an individual who contracts COVID-19 is not a first response employee, these executive orders do not apply to them. The directives from Jack Nolish do. That applies to everyone across the boards in terms of no IMEs during this period and no termination of benefits for not attending an IME during this period, and no reduction in benefits as a result of residual wage earning capacity or not, doing your job search. So anyone else who's not a first response employee should be, you should make the determinations on whether or not it's compensable under, the typical workers' compensation analysis, and I'll get to that in a few slides. We are paying employees full wages under a 14-day administrative leave. It is necessary to file this as a workers' compensation claim if the employee returns within 4 days and there are no medical bills. So in other words, no cost likely to be incurred unless a future/illness occurs. I would still file the necessary paperwork reporting the claim just as you would with any other workers' compensation claim, just because you never know what's going to happen down the line. And if, 6 months from now, God forbid, they come back and say, I went to my doctor and I have ongoing lung issues as a result of the COVID-19 and I need treatment, that claim is there and you have properly reported it. That being said, you wouldn't be in a position where you would have to pay the wage loss benefits until, one, you meet the thresholds in terms of the requisite number of days that the person is off work that you otherwise would on any other workers' compensation claim, and in terms of wage loss, until you don't have something to offset those benefits with. So other payments you're making, which in this case it looks like they were receiving their full wages during that period. So there is no issue as to wage loss. Does the issue of the press and or the employee reporting that there were many false negative tests early on affect whether a claim should be treated in the case of those testing negative? So if somebody has tested negative for COVID-19 and isn't diagnosed by a physician, there is arguably no injury there, right? You don't have a COVID-19 diagnosis, you're not testing positive. There's, that person needs to seek medical treatment and get either a diagnosis or a positive COVID-19 test before I would say benefits, that they're entitled to benefits or to make a claim, really, for that matter. I suppose someone could make a claim and try and make the argument that they had COVID-19, but that burden is on the employee to show that there was an injury. And I think that will be difficult to do without any sort of formal diagnosis from a physician or positive test result. As a vocational rehabilitation expert witness counselor, the job development activities continue for full voc rehab claims should Stokes evaluations be completed during this time. Defense counsel requests them. So this is an interesting case. This is actually something we're facing currently because we have a couple of cases that are lined up for trial in mid-May. I suspect very strongly that they will not go, even if the agency does open up for hearings. I think there's going to be such a backlog from all of the stuff that of the trials that were supposed to go over the last 6 weeks that haven't gone, that those will kind of take priority, and things scheduled in May will ultimately get pushed off. But with that in mind, that's a question that we as attorneys have been facing is, well, what do we do in terms of continuing with the Stokes? If the Stokes can be conducted, if the Stokes interview itself can be conducted over the phone and plaintiff's counsel is amicable to that, I think that is fine to conduct the interview itself for the Stokes report. Obviously, if it needs to be conducted in person, no, that can't be done right now. And you also aren't in a position to, if plaintiff's counsel says no, we're not going to do the Stokes evaluation over the phone. I don't think we're really in a position on the defense end, given Director Alicia's directive, to force the plaintiff to do it at that point. Really, I think the recourse at that point would be when the hearings do pick back up, say, well, we need additional time because we weren't able to get the Stokes. We tried to arrange it over the phone and plaintiff's counsel wasn't amenable to that idea. Once you've done the Stokes interview, do you go ahead and do a job search at this point? That's, I suppose, up to the employer and the attorney handling the case. I don't think there's a lot of value to it at this moment because we are not in a position where we can reduce benefits or terminate benefits based on the results of that job search. Obviously, if you are preparing for trial and it's a do or die trial and it must go and you're up against the wire, you as a Stokes evaluator and I as an attorney can say, okay, go ahead, do that job search. But so you have it and you're prepared for trial in the event that it does in fact go. I think that any jobs that are identified, plaintiff's counsels are going to have a very easy time poking holes in terms of saying, hey, this actually isn't reasonably available to my client at this point in time. I don't think there's any harm in going ahead and doing it, but I think it might be an unneeded expense at this point because you're just going to have to redo it when these orders are lifted anyways, to have good evidence going into a trial. So that's sort of the position I would take in terms of job development activities in full vogue. Anything that's requiring in-person contact and is deemed non-essential is something that really you're not in a position. I would not advise any of my carriers to force a plaintiff to undergo vocational rehab efforts where there were in-person meetings required because it's a non-essential function. And so I don't think that would be looked favorably upon. And I think that they've made it clear through some of these directives. The next one is, and I'm not seeing this if I resent all three. Okay. Okay, please revisit how an emergency responder is handled if they are probably definitely exposed on 3/20, but claim not filed until 3/31. So if they're alleging that the exposure was on 3/20, but the claim wasn't filed until 3/31, I would follow the directives under so you're not aware of the claim until 3/31, it hasn't become an issue till 3/31. I would follow the directives under the March 30th, 2020 order, where it is a rebuttable presumption. So the caveat to that would be if the person was exposed on 3/20 and was at home quarantining at the direction of the employer, obviously that should be covered under the 3/18/20 emergency order in terms of the quarantine. In terms of 3/31, if that's when you become aware that they have the diagnosis, the person is now off work, and 3/30 as of 3/31, follow the rebuttable presumption. The rebuttable presumption supersedes the irrebuttable presumption in place from 3/18 to 3/30, and so that's the guidance I would follow since it does supersede and since it just became an issue on 3/31, even though the arguable exposure was on 3/20. Back to 3/18, at first response employees sent home to quarantine by employer due to symptoms and tested negative. Well, if they were sent home, so in this case, we have a first response employee who was sent home to quarantine by the employer due to symptoms, but then tested negative. Yes, that would be covered under the 3/18 executive order because they were sent home to quarantine at the direction of the employer, and quarantine was specifically covered under that executive order. Since 3/30 order superseded, and the order is now non-compensable. If the person is still off work at this point, but they're testing negative and they're no longer required to quarantine by the employer, no, at this point, if they don't have a diagnosis of COVID-19 and either by test or by a physician, and they're still off work, unless it's still under a quarantine order from the employer, then I would say no, there's no injury to show that's covered under these executive orders because they don't have a diagnosis. And I'm suspecting if the employer went off around 3/18, that the quarantine period would be lifted, given we're in mid-April. But for a period where they were at home quarantining at the direction of the employer between 3/18 and 3/30, yes, I would pay that. I would consider that compensable. And all of my contact information is also on the presentation, and I will be sending you an email after this with a copy of this PowerPoint presentation and all my contact info. So if there are specific questions related to specific claims, which might require some more in-depth analysis, I would be happy to respond to those individually. I know we're running short on time here. So if you want to email me, Terry, individually, because I see you have a number of questions, I'd be happy to answer those. Kind of separate to this. I'm sorry, we're getting so many questions, but I'm also trying to be cognizant of your time because I said I'd only take up an hour. So I want to get through sort of the next couple, and then any additional questions, I'm happy to stay on after and answer at the end, or again, you can email me directly. All right, so that covers the directive of Jack Nolish. The next thing we suspect we are going to see a slew of is psychiatric workers' compensation disability claims. There is a ton of stress amongst frontline workers, including obviously these first response employees, so hospitals, nurses, EMTs, police officers, but also essential workers, these people who are deemed essential, who are going to work every day. So like the bus driver example we were talking about earlier, people who are working as cashiers at the grocery stores and stocking food, people who are delivering packages in the mail. There is a whole lot of stress that all of these people are under, and so we are expecting that we are going to see a surge in psychiatric claims, which is something we wanted to make you aware of. To determine compensability of a psychiatric claim, one must consider were there actual events in the employment. Was the worker's presumption of those events unfounded? That's evaluated on an objective basis, whether or not they were grounded in fact and reality. And while the worker's perceptions of the work events are to be objectively evaluated, their reaction to those events are to be subjectively examined. So, if you're a frontline worker and you see a number of patients code, and your perception that, that these people died and, it's horrifying, that's reasonably grounded in fact or reality. Now, how that person reacts will be evaluated on a subjective basis, and what that means is, whereas one person who sees those things and it's horrible and awful, and they break down and they can't work for a month or two because they just can't intubate a patient at this point, that's how they subjectively perceived it. Then the other person might never be able to walk into a hospital again because they're so petrified from the experience. Both people experienced an actual event and had a reasonably grounded perception that as objectively evaluated, but their subjective response is different, but both would be arguably covered. Was the contribution of the work event to the worker's psychological condition significant when compared to avocational factors? So, you have to look at what else is going on in the person's life. So if you have somebody who's bagging groceries at the Kroger and they're scared every day because they think they're getting exposed to this disease and they're under so much stress, and they're seeing people come in who are sick and coughing on them, and obviously that's an actual event and it is occurring, and you could objectively be scared and have stress and develop a condition as a result of that. But what else is going on in their life? Are they getting divorced? Do they have other health issues that they're stressed out with? Do they have pre-existing psychological issues that they also are dealing with? So there's that balancing act there that will also be considered. Just wanted to make you aware there's proposed legislation in Michigan. 20 other states have enacted similar legislation with regards to post-traumatic stress disorder claims made by first responders. First responders is not necessarily defined in the same way it was for those executive orders. This has not become a law here in Michigan. It is under consideration and sitting at committee level in the Michigan House of Representatives. But if the proposed legislation was adapted into law, it would create a rebuttable presumption that a first responder's diagnosis of post-traumatic stress disorder arose out of and in the course of employment. So that's something we may see coming down the pipelines. It's not here yet, it's not at our doorstep, but we just wanted to put it out there and make you aware that there is a bill under consideration and 20 other states have adapted it. So that's something to keep in mind. All right, is contracting the coronavirus a compensable injury if you are not a first response employee? So many of us are not first response employees, right? And many of the people that you are working with and the claims that you're seeing coming across your desk, they are not necessarily first response employees as defined under these executive orders. They're the bus drivers, they're the cashiers, they're the baggers, they're delivery people, they're receptionists in office settings. So are these claims going to be compensable for other people outside of these sort of first response situations? And that answer is going to be on a case-by-case basis, and it's going to be a factual determination, basically running through the typical steps you look at when you're evaluating a workers' compensation claim. The issues that we're going to need to consider is, one, whether the coronavirus will be considered an ordinary disease of life. And if so, does MCL 418, 401, 2B exclude COVID-19 from coverage? So basically, 401, 2B states that an ordinary disease of life to which someone is exposed outside of their employment is not typically compensable. But then there's the issue of whether this exclusion under 401, 2B applies equally to occupational disease claims and to personal injury claims, or does it really just limit compensability under an occupational disease claim? And we're going to have to look at, are these claims being made as an occupational disease or a personal injury? It appears highly likely that these claims will be evaluated as personal injuries as opposed to an occupational disease. Occupational diseases are typically diseases that are in conditions that are characteristics and peculiar to the business of a specific employer, versus an ordinary disease of life that the public is generally exposed to outside of employment. The coronavirus isn't peculiar to any one set of employment or any one industry per se. The coronavirus is impacting people worldwide. You can be infected with the coronavirus regardless of your occupation. It doesn't matter if you're working as a doctor on the front line or if you're a school teacher. Anyone can get this disease, not just people working in a specific capacity around things day in and day out. And the coronavirus, there's actually a case in Michigan, Roberts versus Western Michigan Foundry, where they noted a lung condition caused by continual exposure to foundry dust would be compensable as an occupational disease, whereas a lung condition caused by a sudden exposure to like a chemical not encountered in everyday employment would be equally as compensable, but just as a personal injury. And we think that's more where the coronavirus falls. Your contraction of the coronavirus is a single event incident. It's not a result of continual ongoing exposure. You were either exposed or you weren't. And at that point you were exposed, you contract the disease, or the virus rather, and that falls more into the category of a single event injury because it's not peculiar to any single set of employment. So looking at it as a personal injury, then we have to determine whether the employee, and this is really the key, whether the employee can establish by a preponderance of the evidence that his or her actual contraction of the virus occurred in the course of employment. For a lot of people who are not first response employees, this is going to be hard to do. It's a heavy burden for an employee to show that they they were exposed at work, and that's where they contracted it, especially when they're going out and they're going to the grocery store, or they're pumping gas, or they're in other areas where they could potentially be infected. They're going to need to show that that injury occurred in the course of their employment, and the burden is on the employee to prove that, which will be more difficult, especially the more that person is active and out and going places, and exposing themselves in other venues. You're going to have a more difficult time if you have a bagger who's working in a grocery store and the only place that they are going besides work is home, where everyone in their house is self-quarantining, because you're just not going to have they're going to have an easier time saying this is the only place that I could have contracted this. Whether an employee could be able to, so then you look at the second factor, which is whether the employee would be able to establish by a preponderance of the evidence that their contraction of the virus arose out of your employment. Historically, Michigan included, some jurisdictions use the increased risk test to determine if an injury arose out of the course of the employment. And so we need to look at whether an employee is in an increased risk capacity. And so I think you're going to have an easier time proving that if you are one of those essential employees. So going back to the bus driver example that somebody brought up in one of the questions, there's an employee that's dealing with the public day in, day out on a very regular basis. They are deemed essential and that the buses are still running. They are still expected to be at work. They are in a confined circulated space with recirculated air. They are at increased risk. They have high contact with the public. They have contact with the public who is still out and who is still moving, and they're in a confined space. I mean, I think it would be easy to argue increased risk in that type of situation. So you're going to have to look at the risk the person is exposed to. Now, let's say you are a receptionist for a business that all the other employees are working remotely at home, but you are going in to maintain the minimum level necessary to maintain the business. So you're in the office alone by yourself. And, on your way to and from work, you stopped at the gas station and you went to the grocery store. One, you're going to have a hard time showing the injury occurred in the course of your employment because you were doing these other things. And two, you're going to have a hard time showing that it arose out of because you weren't necessarily at increased risk. You're not interacting with the public. You're not you're not in a crowded workspace where you're in contact with people constantly. So it's going to be a factual analysis based on increased risk to that person. And going back to that, I think that you're going to see people who have been deemed essential employees and who are out there working long hours with the public are going to have an easier time trying to make an argument that they're at increased risk, especially since there are these stay home, stay safe orders, which are specifically because there is increased risk by going out in public, right? Issues arise. So then the next issue that comes up is remote work. So, okay, you're not an essential worker. You're not off, bagging groceries at Kroger right now or driving a bus for the city. You're now at home working, and your employer has, many employers have not just given people the option to work remotely, but they've said, okay, we're going to work remote. I know that's what we've done. We've moved to a remote workforce for the time being. So, I'm here at my home office and I'm all set up with, multiple screens and office equipment that 3 weeks ago was not here, but now it is. Here we are. And I brought all my work equipment home, all my documents, all my papers, all my files, and, have set up shop. So we're going to see a big increase in claimed injuries that occur while a person is working, but while they're working from their home. And this brings up a lot of issues. It's during the workday, the person's, logged on, they're taking calls, they're answering emails, but then they run downstairs to change out their laundry and slip and fall on their way down the stairs and, break their leg. Is that a compensable injury? I mean, they're working from home, it's work hours, it's a small deviation from employment. we're going to start seeing claims arising like this. And I think that those are going, I think those are going to present some challenges, and there's going to be some real issues and factual determinations that need to be made as to whether they are compensable. I think the things that we really need to look at are what activities was the at-home worker actually performing at the time they were injured? Was the worker required to work from home, or was it permitted for their convenience? In most cases right now, people are being required to work from home. Did the at-home work arrangement place the worker at an increased risk or perhaps decreased risk? And so other things to kind of consider is, did the employment subject the employee to the actual risk of injury? In that case, it's probably likely. At-home injuries to a telecommuter in the course of their employment. If it occurs, did it occur while they were actually doing business? So it will probably be considered in the course of. So let's say you have an employee and they're running on their treadmill, and while they're running on their treadmill, they're watching this webinar at your direction, or they're taking a work-related phone call. They've got a strong argument that that injury arose in the course of their employment because they were working when they hurt their leg running on the treadmill. But you have to meet both prongs. So the next question is, well, did it arise out of the work activity, or did it arise out of the fact that you were running on a treadmill and that, you're not very good at it? Were you distracted from work, from the work call you were on? Something so shocking happened on the call that it caused you to fall off, or, did you just trip? Is it enough of a deviation from your work that you were running on this treadmill to take it outside the scope? So these are the things we're going to be looking at. I think the things that are clearly compensable are examples of, you've got an employee, they're working from home, work supplies are being shipped to the house. And so they go outside their house and shovel their sidewalk off so that they can get to the package that they've, left to be delivered. That's probably compensable, because the purpose of going outside onto their porch in the icy weather is to get the package, right? And the package was sent because it's got your work materials in it. So it's clear that the employment subjected the employee to that injury. So something like that would probably be compensable, whereas something like the treadmill example, there's a lot of factual issues at play, and there's definitely room to argue that although it was in the course of, it didn't necessarily arise out of, particularly because running on a treadmill is personal in nature and it's really unrelated to your job. I mean, typically if you're, an attorney, you're not running on a treadmill in your office. And so you have to think about that. Hazards of a home encountered in connection with performance of a work, are hazards of the employment. So if your printer is on the second story of your home, but your office is on the first story, that's how we have it set up, mostly just because we don't like our kids hitting the buttons on our printer all the time, which they love to do. So it's up in our bedroom where they can't touch it. But obviously my office is downstairs. If I run upstairs to get something off the printer and fall on my way down because I trip over, my kid's toy on the stairs, arguably that could be compensable because it's an ordinary hazard of the home, which is now my work environment. And I was running upstairs to get work documents off the printer and come right back down to my office, to finish doing whatever I'm working on. Just the same as if somebody tripped walking from, their office to grab a cup of coffee in the lunchroom. That's arguably compensable as well. They trip on the rug in the hallway. So these are the things that I think we're going to be seeing a lot more of, and issues we're going to be needing to address. The last issue is, would an employee working from home ever be able to establish that their contraction of COVID-19 is compensable? I think this is going to be particularly difficult, especially because you're going to need to look at whether the work from home arrangement placed them at an increased or decreased risk. And I think, in most cases, people are working from home because it is placing them at a decreased risk. We are way over on time. So tried to rush through those last couple of slides. I know there are a ton more questions, and I will happily stay on and answer them. But for those of you who need to get going, since I know we've exceeded our time, please, feel free. Again, my name is Alicia Birach, and I'm with Foster Swift. I have up here a visual of our entire workers' compensation team. There's over 5 attorneys who practice workers' comp specifically with over 100 years of experience. In addition, Foster Swift is a firm with over 100 attorneys and many different practice areas. So if you have any questions or concerns, either for workers' comp related purposes or anything from business to employment related issues, I know things are coming at you fast and they're coming at you furious, and things are changing almost on a daily basis, it feels. And I know that your questions, are probably not just limited in scope to workers' comp, but we have an entire team of attorneys who are here to help you with both the comp issues and any other ancillary business or employment issues that you may be facing during this very challenging and ever-changing time. I also have some resources. This will be sent over to you in an email, which connects you with our workers' compensation blog and our e-blast. Also on the firm's website, there is an entire coronavirus resource page, which features resources from all our different practice areas. So if you have business questions or employment questions, or you're concerned about how the CARES Act impacts something, please feel free to go on there and take a look, and they do a nice job breaking down that information for you. I'd like to thank you all for taking the time out of your day to sit here and listen to me talk about all of these changes. If you would like to be included on our newsletters with updates on the changes related to COVID-19 and Michigan workers' compensation issues, please go ahead and send me an email. My email address is on the screen, or like I said, I'll be sending out this presentation later. So if you just want to respond and say, hey, please include me, I'd be happy to add you to our list. Like I said, things are changing. It almost feels like by the minute at times. And so we're trying to get as much information out to everyone as possible to keep you apprised of, the different changes that are being made. So as soon as we know, and we can all work together to get through this and get some of this stuff answered. Now, like I said, I will stay on and answer any questions, but please feel free to hop off. I know, this has gone long, so I'll stay on for a few more minutes and answer as many questions as I can. But if your question wasn't answered, feel free to email me, birach@fosterswift.com. Again, A is an apple, birach@fosterswift.com. And I'll make sure to send out an email to you too. But I'm happy to take any emails or questions, and feel free to give me a ring at any time as well. We're still working 24/7, albeit remotely and in sort of a new office setting. So, all right, well, thank you guys very much. And again, I'm going to take some of these questions, but if I missed you, just shoot me an email. All right, if the responder employee is sent home for exposure, but the test is not done for several days because they're a lower priority, a negative, is the responder likely covered for workers' comp while the initial test is pending or the test result is pending? Yes. If the responder employee was sent home for the exposure by the employer, they would definitely be covered under the March 18th guidelines, or executive order. Under the 330, they wouldn't be. So it depends on when you sent the person home. In terms of the irrebuttable presumption. Now you have to keep in mind that even though the March 30th guidelines or executive order don't include the quarantine period, that's just not including it in the rebuttable presumption. So if somebody subsequently gets COVID-19 and you'd send them home, yeah, I'd arguably say, I think they have a strong case to say, hey, this was work-related, I should have been compensated via workers' comp or some other capacity. If they ultimately test negative, which it looks like they did in this case, if it was after March 30th, they were sent home at the direction of the employer to self-quarantine and they weren't negative, they don't have an injury because they don't have a COVID-19 diagnosis. So it wouldn't be workers' compensation leave after 330 because again, 318 during that period, if you sent someone home before 3:30, so between 3:18 and 3:30, you sent somebody home to quarantine because they had symptoms, that first order was in effect and it was an irrebuttable presumption, so you would have to pay for that period. After 3:30, the quarantine period is not covered, so it's not even subject to the rebuttable presumption. And in this case, the person ultimately tested negative, so they're not going to be able to show an injury because they don't have COVID-19. But you did send them home. So would that be covered under workers' comp? No, not necessarily, but there might be some ancillary, employment issues there in terms of, you had them off work and, they weren't compensated. So that's more probably going to be dictated by your employment policies for that period, as opposed to workers' comp, since there is, no injury. And as of March 30th, the quarantine period isn't covered. Got a case, thank you. So I have a request for the Roberts case we cited, which we will gladly get over. First response employee sent home prior to 3:18 by employer for symptoms. Test took several days. Some even lost in transit. Test ended up negative. The testing is taking quite a long time, which I know is a huge frustration, especially because these people are off work for long periods and then they end up testing negative. Negative. So the last question I have is first response employee sent home prior to 3:18 by employer for symptoms. Test took several days, some even lost in transit. Tests end up negative. If they were off during the period that the 3:18 order was in effect, so if they went off, let's say on 3:15 and they were still off on 3:20, and they were off at the direction of the employer, the 3:18 order dictated during that period and they should have been paid because they were quarantined at the direction of the employer while they waited for the test results. Once the 3:30 order took effect, if the person was still off and still quarantining at home at your direction, arguably at that point, you didn't have to pay them anymore, subject to the irrebuttable presumption. If they had tested positive, then I would say you should have definitely continued because you're going to have to pay them under the 3:30 order as well. But since they tested negative, there is no injury. So technically you could cut them off as of 3:30 because you had no obligation to pay for the quarantine because there's not an irrebuttable presumption that they had a personal injury arising out of an in course of employment as of that 3:30 date. Excuse me. And ultimately, since they tested negative, they wouldn't be entitled to benefits because there is no injury that occurred. The thing that people need to keep in mind is between 3:18 and 3:30, being sent home to quarantine under that executive order was considered a personal injury. So they're saying, if you're at home and you're quarantining at the direction of your employer, that's a personal injury subject to this act and it's irrebuttable and benefits must be paid. But then the 3:30 came along and superseded it. So as of 3:30, if they're still off for quarantine, at that point, you didn't have to continue paying. And they ultimately tested negative. So there is no issue as to whether they have an ongoing personal injury because they don't have the coronavirus. I hope that answered your question. If anybody is still on whose questions weren't fully answered, please go ahead and email me. My contact information, including my phone number, is on both the first slide and then the slide with the names and contact information for everyone in our practice group. So feel free to call or email me directly. And there are a few of you who had some specific, pretty fact-intensive questions. So I will do my best to try and reach out to you individually and follow up with you to make sure that I got all of your questions answered. And if there are additional facts that I need or you have follow-up questions, we can kind of hash those out then. All right, so I'm not seeing any other questions at this point. Oh, wait, okay. So It didn't, so the last question I have is, did the 330 order make the 318 order null and void? It didn't make the 318 order null and void, it just superseded it. So as of 330, it overrides everything, you know, in the prior order. So the prior order, they're not two individual orders. It's not this 318 order or the 330 order. As of 330, we're just looking at the 330 order going forward in terms of how do we deal with first response employees. But if you have a first response employee who was off work prior to 330, that 318 order is in effect. So during that period between 318 and 330, you have to look to the 318 order for guidance on how that claim should be handled at that point in time. Then when the 330 order went into play and superseded, well, now you're not in a position where there's an irrebuttable presumption or where the quarantine period is necessarily covered as a, you know, personal injury subject to workers' compensation benefits under an irrebuttable presumption. And again, if there's additional follow-up questions or I'm not, you know, clarifying this, I'd be happy to sit down and have a conversation with you over the phone so we can kind of go back and forth on this. All right, well, thank you very much. And I appreciate it.